Hello and welcome to Point One. 6 minutes of ethics a day could keep the legal malpractice claims away. Today I want to talk a bit about legal malpractice claims and specifically the first element of privity. So legal malpractice, generally speaking, everybody's familiar, but most people are familiar with the case within a case requirement. And the elements are important, as with any tort, with any claim. You hear people say all the time, that would be malpractice. And what they're really talking about is the breach of the standard of care. They're ignoring all the other elements, which, of course, we can't do. So the four elements of malpractice, as I'm sure most of you know or remember from law school and the bar exam, is privity, the attorney-client relationship. Negligence is the second, and a breach of the standard of care. Proximate causation is the third, and then actual ascertainable damages is the fourth. In subsequent vlogs, videos, I'll talk about the other elements, of course, but today I wanted to discuss privity and sort of the ethics as it impacts claim for legal malpractice. Of course, you have to know the rules of each jurisdiction you're practicing in, and always keep that in mind. The attorney-client relationship creates the duty, and it's often forgotten, even by attorneys, that a legal malpractice plaintiff almost exclusively can only be your client. Only your client can sue you for malpractice, with very, very few exceptions, especially in New York. New York has a very strong privity standard. On the other end of the privity spectrum is probably California, where intended beneficiaries, especially in the trust and estates context, could have claims. But in New York, strict privity is a big hurdle. And, I've had cases where an underlying personal injury claim where a husband and wife believed they were represented by the attorney defendant. The husband suffered serious injury on a construction site and spoke a foreign language. The wife acted as an interpreter. She had her own claims. They were dismissed early for loss of consortium and services. They paid with marital assets. They paid the attorney. She met with the attorney several times independently, spoke with the attorney on the phone independently. And ultimately, we were able to get those her legal malpractice claims dismissed because there was a retainer agreement with the husband only, and the surviving claims were only brought on behalf of the husband, which ultimately led to the legal malpractice claim, which we also were able to defeat. The privity, that ties into the payment of services under privity. In New York, it doesn't matter who's paying your bills. The client is the client at the end of the day. And again, the client's the only one who really can sue you for malpractice. This is where the scope of services in the retainer agreement is so key, because once you create that duty, once you accept someone as your client and they accept you as your attorney, unless the scope of services is clearly delineated, you really do broaden your risk to potential claims way outside of the anticipated role. And this could be anything from, taking on a plaintiff's personal injury case that then leads to an appeal, which you as the attorney had not anticipated, or, a completely unrelated criminal transaction or something of that nature where you get sucked in, or just allegations are made that you somehow dropped the ball, in failing to represent the client. So the retainer agreement is key, and strict scope of services is so important. There's, of course, a problem with jury perception. And, I often hear that juries don't like lawyers. I haven't found that to be particularly true. I think juries don't like liars and thieves and things like that. And, it sort of depends on the case, but I found juries to be very receptive to attorney defendants. The problem, I think, of jury perception is that they sort of accept this idea that you hear from plaintiff clients a lot, that, well, he was the lawyer, he was supposed to handle it. I thought the lawyer was handling it. And once I hear that, the lawyer, it signals to me that this is going to be a jury perception problem, because I think juries reasonably can think, well, that makes sense. I would expect my lawyer to handle that aspect. Even though he was just my personal injury attorney, I told him I got arrested, and I told him I had a court date. I would expect him to show up and defend my my criminal proceeding. Now, attorneys, of course, don't think that's reasonable, but again, there is that jury perception problem that the lawyer was supposed to handle it. Specifically, ethical considerations and the privity element Of course, you have to know your jurisdiction's rules, and the model rules are instructive. The retainer agreement and all of the rules surrounding our use of retainer agreements and contracting with clients generally are going to be at issue. Client communications, and again, dealing with spouses here. While we were able to defeat that legal malclaim brought by the wife of the underlying client, I think it was still a failure, a professional failure. It didn't amount to legal malpractice, but it should have been made very clear in writing that the spouse was not the client, and the only client was the husband, personal injury plaintiff. And contemporaneous written communications are really the key to providing a best practice, best product, but also mitigation of risk and protecting. The CYA email can't be oversold in protecting attorneys. Special considerations for incapacitated, incompetent clients, unrepresented parties, and non-party witnesses. Arbitration clauses, fee dispute clauses, things like that, they're pretty regulated in retainer agreements, but of course that's an issue. And just very quickly, the attorney-client privilege and the at-issue doctrine. Even if your client sues you, you have to maintain privilege, of course, but if the client uses that privilege against you and puts it at issue, then there's a waiver of the privilege. It's not a wholesale waiver of the privilege. You can't publish all the privileged information you have on the client, but you can use the privilege information to defend against the lawsuit if it's at issue. And the client can't use that privileged information as both a sword and a shield. That's been our point one for the day. Thank you for joining.